This is Dish and Dirt with Gary Pickren, South Carolina's only podcast dedicated to the real estate agent craft. And now, the host of Dish and Dirt, Gary Pickren.
And greetings, welcome back everyone to another episode of Dish and Dirt. I'm your often opinionated, rarely wrong host, Gary Pickren, coming to you from the beautiful downtown Columbia, South Carolina offices of Blair, Cato, Pickering, Casterline. This, the last week of August 2025. On our show this week, we are going to talk about all of the changes to the CCRA contract. That contract will be coming out here, it looks like, the end of September. It was just a few months ago that we went over the changes to the SCR contract, and being basically the entire South Carolina market uses these two contracts, whether you use the CCRA contract or not. You're going to want to listen to this week's episode, because if you are anywhere in South Carolina, there's a good chance that you might be presented with a CCRA contract, or you might actually be looking to help a client in this area. So it's always a good idea to know not only the state contract, but the Central Carolina REALTOrs Association contract. Before I begin, I do want to thank everybody on the real estate contract committee that's led by Becky Ashby and Matt Carroll. They do an outstanding job, and I don't think a lot of people understand how much time is involved, not only with the weekly meetings to go over not only the contract, but addendums and other forms that have been either suggested or actually drafted or revised. But outside of that, Becky and Matt themselves do a lot of work drafting, redrafting, formatting, sharing ideas, talking about it, meeting with me and others, trying to come up with the best contract for the marketplace. And I think, quite frankly, the CCRA contract is an outstanding contract. I'm a little biased, but I think it is the best contract out there. I have been on the contract committee now. I think I'm going on about my 18th year. In fact, when I joined the contract committee, I did not have a daughter. My wife wasn't even pregnant, and now my daughter's a senior in high school. It has been a while since I wasn't on the contract committee, but I do want to thank everybody and all of their hard work, and also Taylor and Kim at the association for constantly pushing and striving to have the best contract and the best forms and the best documents of any of the associations out there. And I think that Kim and Taylor do an outstanding job at CCRA, as well as I think all of the other associations, your local associations like Sumter and Myrtle Beach and Greenville and Spartanburg. I think they also do outstanding jobs. Again, as I've mentioned multiple times, you can be pissed off at NAR, but you have to really appreciate the hard work that SCR does, as well as your local associations do for you guys. They're outstanding professionals that truly are trying to do the best they can to help you. And I know at times it seems frustrating that, you don't like the fine system, or you don't like how they run things with the MLS, but, they're doing the best they can with what Sister Burnett has given them. And it's not always wonderful, but I promise you, all of the associations have the marketplace, the realtors, the associate members, everybody's best interest at heart. I am happy to say that I'm a proud realtor, and I'm a happy member of multiple realtor associations in our community, and I'm happy to say that. Now, before we get started going over the CCRA contract, I did want to thank everyone who was able to come to our grand opening in Sumter. It was wall to wall, nowhere to move. We had so many people in there, and it was a really fun afternoon. I was really excited to see a lot of the lenders and real estate agents in the marketplace, and even a few attorneys that Vonda knows in the marketplace as well. It was really nice to see that turnout and the support we got, not only from the market, but also from the Chamber of Commerce. So thank you very much in Sumter, and also at the Commons in Greenville. I don't think I've ever been to a grand opening that had so many people. All of the rooms were taken, the conference rooms, the waiting area. We even spilled out onto the veranda that overlooks the food court. It was an amazing night, tremendous crowd, and just very excited for what the office has to offer there. As I've mentioned before, you can do a closing with us, and while you're waiting on your funding, you can go downstairs and have a beer or get a coffee or even get a lunch, and we give you a restaurant-style pager to let you know when your funding is available. It's just one of the many neat things that Adam and Kelly and the guys up there have come up with that I think you're really going to enjoy for your clients. In fact, if I was a real estate agent, I would do my closing at 1, meet my client for a buyer side at 2 o'clock, stay there and do some work at 3 and 4, and head home. You almost can use the Commons as a temporary or as a second office when you have closings. And it's just a beautiful, wonderful, comforting space over there. And I think you're really going to love doing closings in our Greenville office. Lastly, September 4th, coming up here in just a few weeks, we are going to do a meet and greet with our Spartanburg staff at Dre Bar and Grill. If you are in the Spartanburg area, if you're a Greenville Spartanburg agent, or from any other area, even Union, Gaffney, wherever, you want to come out and meet Carson and Alicia and get to know our brand new staff in the Spartanburg office, come join us at Dre Bar on September 4th, and that's going to be from 4 to 6 p.m. as well. We look forward to having you there. Now let's talk about the contract. We got a lot of changes in the contract. Do keep in mind, anytime you make changes to the contract, we have to be very careful in making those and really look at, is this a change that a lot of agents would benefit from, or is this just a change that happens once in a blue moon? If it's going to benefit the better marketplace, then we are going to try to make those changes. But if it's something that happens randomly, then we're not going to put that in the contract because it's already 9 pages and we don't want to make it 90 pages. We're going to do everything we can to try to keep the contract short, but also cover all of the things that you as real estate agents need the most to have in the contract to protect your clients and to also help you do your job. Page 3 will be where you start seeing the first change. Everything's highlighted in yellow of what we changed. Paragraph 9 being the first change. This is a home warranty coverage. We actually debated at the Real Estate Contract Committee as to making this an addendum like the state did. If you'll remember, when we went over the state contract, they pulled the home warranty out of the contract and put it as an addendum. We decided as a committee to leave it in. The board also agreed with that. But we did put this statement here at the end of that paragraph that says brokerage firms and or their affiliated agents may receive compensation or administrative fees from the home warranty company for completing administrative acts on behalf of the home warranty company. This fee, if applicable, will be paid to the brokerage firm ordering the warranty. The amount of compensation for this home warranty, if any, is blank dollars. Again, this was a change that we're seeing across the country. NARS wanted this change because apparently there are some brokerages that do accept money on behalf of home companies for placing a client in a home warranty. My suggestion, my opinion is never ever do this. I think this is very, very dangerous. I've represented many brokerages throughout the years. Many years ago, back in the 90s and early 2000s, most brokerages did accept money like this. They would accept $25 as a commission for putting somebody into a home warranty. But what would happen is when a home warranty claim was denied, and the homeowner knew that you were receiving a commission, albeit just $25, then the complaining started. Had you not put me in this home warranty because of that $25 commission you made, you would have put me in another home warranty company that would have covered this item. You aren't doing what's best for me. You're doing what's best for you. You're making money. That's why you put me in this home warranty. Some would even say this is the only reason you put me in a home warranty was so you could make the $25. As absurd as that sounds, that is a great arguing point for a plaintiff's lawyer to try to stick you with the repairs. It's my opinion, as it is most lawyers that I've talked to, that you absolutely should never accept money for referring somebody to a home warranty. The amount of money that you make over that, over your life doing that, is minimal when it comes to just one claim under a home warranty that's denied, and then the client claims because you've made all this money selling their home warranty, you put them in that home warranty when the other home warranty would have paid for it. It is not worth it. I think it is a bad decision to do that. But that is the change that NAR wanted. And so that change is now in paragraph 9, home warranty. Now we're going to talk about the big change. This is the transaction cost change. And there are 2 reasons that we had to go with this change. First of all, as I mentioned last week, congratulations. It is the 1-year anniversary of Sitzer Burnett. So you made it through a year. The economy didn't crash. Real estate didn't go away because of the Sitzer Burnett case. You didn't go out of business. You didn't quit making money. You didn't stop working with buyers because how hard it was going to be because of these stupid rules. No, quite frankly, business continued in a lot of ways. Those people who embraced these changes and pivoted, they're doing better than ever. I think some of these changes are stupid, but I think a lot of them are very, very good. And because of those changes, we've had to pivot in how this contract is drafted. And if you'll remember, one of the big issues when the contract came out was whether or not commissions could be part of the contract. In the past, it was argued they could not be part of the contract, but that really had to do with how you got paid, because you were not getting paid, more than likely were not getting paid by the buyer or the seller in the transaction as a buyer's agent. You were getting paid by the listing agent through the MLS agreements. When they put in the MLS that they were paying X percentage and you were going to get half, that was really an agreement between real estate brokers and brokerages, and it didn't have anything to do with the buyer or seller, and trying to interject how you got paid into a contract that had nothing to do with you was kind of problematic. But after Sitzer Burnett, that is not the case anymore. That's not at all how real estate works. Quite frankly, Sitzer changed everything for the better. We're still now getting paid. If you're a buyer's agent, you have an agreement with your buyer, and your buyer is asking the seller to pay a portion or some of or all of that commission. Whether it is paid broker to broker or not broker to broker, is still based on the same concept. There is no obligation to pay a buyer's agent, and without some written agreement, the buyer's agent doesn't get paid. And so that's changed how we've had to do everything. Thus why we've come here. I kept making the argument from day one that commission could be part of the contract, but it was not being included in the contract and it was being done other ways. Now, as has happened throughout this entire year of learning, we've learned new things. We've had more conversations. Experts have looked at things. Lawyers have looked at things. Realtors have looked at things, and they've all agreed that yes, we can now put commissions in the contract. We could have always, the entire time we could have, but the NAR just didn't feel comfortable with that, and now they do. So now we are going back and changing the contract to add compensation. It's not unusual to when you have a big settlement for these things to happen and for changes and pivots to happen, and that's where we are now. That was the first reason we had to do the changes to the compensation. The second reason, and really the main reason, in my opinion, is for some reason agents continue to screw this up. And it's baffling to me that real estate agents, and I'm not saying all, but a good number of them, unfortunately, haven't figured out how to get paid. I can tell you there's probably not a lawyer in America who hasn't figured out how to get paid. And about every lawyer in America can divide by a third, even if they're not doing personal injury. I don't know, maybe it's inherent in lawyers that they like to get paid, and real estate agents maybe don't. I don't know. I feel like every real estate agent I know wants to get paid. It's kind of baffling to me that a real estate agent wouldn't spend the time, effort to try to figure out how to get paid. Well, the problem we were seeing as closing attorneys, and I have talked to a lot of real estate closing attorneys about this very issue, and they all say the same thing, that real estate agents complete the contract incorrectly. And what you will see is a Form 120 or some type of compensation agreement signed, and then you will find that the agents will restate the terms of the Form 120 or compensation agreement in the contract. And it looks like they're just repeating it. It doesn't look like it's double. But I've literally had a real estate agent do it that way on 2 closings in the same week. One week she said it was an addition to, and the other week she said it was just a restatement. No way that anybody could look at the two of them and determine that there were 2 different ways of getting paid. Real estate agents were just absolutely screwing this up, restating compensation, and it was becoming an utter mess. One of the main reasons we made this change is to hopefully eliminate this so that anybody using this contract, CCRA contract, can be very clear on what their compensation is. Let's look at what our changes are. We're going to start with paragraph 10. In paragraph 10, the first paragraph is about buyer transaction costs and seller transaction costs. Those transaction costs stayed exactly the same as they were in the old contract. However, we changed the wording in the contract from the referring to buyer broker compensation, and we now call it contractually agreed upon buyer broker compensation. In the previous contract, which I got here in my hand, we used to call it previously agreed upon real estate brokerage fees. And so what our concern was is if somebody saw that and they claimed that you had signed a Form 120 prior to presenting the contract, then they would claim that your buyer transaction cost was previously agreed upon. And so therefore, it's no longer a part of this contract. We were worried about people arguing semantics and trying to get all tongue twisted in that. We changed it to contractually agreed upon buyer broker compensation. What that means is whatever the buyer and the buyer's broker have agreed upon, that is a buyer transaction cost unless we have some other agreement signed. Seller transaction costs is now has the provision contractually agreed upon listing broker compensation. Whatever the listing agent and the seller have agreed upon is a seller transaction cost unless we have some agreement to the contrary. Under Section 10A, we have the header that says contribution toward buyer obligated brokerage compensation. Why does it not go both ways? Well, the committee talked about it for a long time, and no one could come up with a single situation that they could remember in their careers. And I've been doing this 30 years. I couldn't remember one either, where the buyer agreed to pay the seller's commission. It's always the seller agreeing to pay the buyer's commission, or both parties pay their own commission. But rarely, if ever, have we ever seen a buyer agree to paying the seller commission. Maybe it's happened in your life. I don't know. It's not really up for debate, but it happens so infrequently that if that situation arises, you can do that through an addendum, but it does not need to be part of our contract. Section 10A truly is about a buyer being obligated to pay a buyer's agent, and now they're asking for the seller to pay some or all of that brokerage compensation. The paragraph begins, if the compensation of the buyer's broker is to become part of this contract, the parties have attached the appropriate buyer broker compensation agreement. In the parenthetical, it says SCR Form 120 or similar form, and the form should be referenced in paragraph 21. What we're trying to do is eliminate the situation where parties have to go out and try to get a Form 120 signed before they submit the offer. You should be able to submit your offer and your Form 120 or your similar compensation form together as one and say, this is our offer. We're offering this to buy the house, and we're asking you to pay this amount of commission. And it should be able to be done as one and not separately. If you do it together as one and they become one, then it becomes one agreement combined, and you need to reference that in paragraph 21. This is the best practice. This is the best way of doing it. Now, I do want everybody to keep in mind that a compensation agreement and a contract are two separate documents in and of themselves, and they can be signed separately at separate times, and they are both still binding. If you've already gotten a Form 120 signed or a compensation agreement signed, and then you get the contract signed and you didn't attach it and you don't reference it, it doesn't make the Form 120 or the compensation agreement invalid. It still is a contract in and of itself. It remains valid throughout the whole time. Never changes. If you sign the contract first and then you negotiate a compensation agreement or a Form 120, even though they're not signed at the same time and not referenced in the contract, they are still two separate binding contracts. However, what we're saying here is if you want to submit your offer and submit your compensation agreement together, what this eliminates is the seller's ability to sign the contract and then refuse the compensation, because this now would all be as one contract. We don't have a ratified contract. If I submit to you a contract, and as part of this contract, and I reference it in paragraph 21, stating, the compensation agreement attached here too, you can't sign one and not sign the other. If you don't sign one, but you sign the other, what that is a counteroffer. Now I get to come back and make another counteroffer. You're not stuck. You're not stuck with that if they do that. I also want to say that if I attach it, but I don't reference it in paragraph 21, it's still going to be part of the contract. Don't get all wrapped up in semantics. We have too many agents out there who try to be lawyers and get, well, it was attached to the contract with a staple, but it wasn't referenced in paragraph 21. Therefore, it doesn't count. It still counts, people. It really does. Again, the two documents are separate documents in and of themselves. We're just putting them together as one in this situation. We finished that sentence or that paragraph with closing attorney to document broker compensation on the settlement statement and to collect and disperse broker compensation in accordance with the contract or other attached agreement. I don't know. That was in the state contract. I don't really know why we put it in there, but it sounds nice. It tells closing attorneys to do it. We already been doing it. I've been doing it for 30 years without being told, but whatever. We'll put it in there without any issue. The next sentence in paragraph A is part of the settlement. Under no circumstances shall any broker receive compensation at an amount greater than agreed to in the signed agency or transaction brokerage agreement. You cannot get paid more than your buyer has agreed to pay you. It doesn't matter what the seller's agent or the sellers agreed to pay you. The maximum dollar you ever can make is what you've agreed to with your buyer. No ifs, ands, or buts about that. If I've agreed with my buyer and my buyer is going to pay me X and the seller said, I'll pay you X times 4, I still can only get X. I cannot get paid more than my buyer agreed in my buyer representation agreement. Question begs then, can I amend it? We've talked about this before. The answer is very limited opportunity to amend. You may only amend your buyer representation agreement if you provide additional services. You may not amend your buyer representation agreement to capture more commission for you. If I'm representing you and you've agreed to pay X and I show you a house and that builder says, well, we're offering a special paying X times 2 to all of our great agents, I cannot go back to you and say, I would like to double my commission. Not coming out of your pockets, coming out of the seller. They're the ones who agreed to pay me. Let's amend our agreement. The answer is you cannot. That's unequivocal. Nobody is saying you can do that. All the lawyers involved in the lawsuit say you can't do it. Catchmark says you can't do it. NAR, SCR, all the local associations say you can't do it. Anybody telling you that you can amend your agreement to capture more commission is flat out lying to you. They don't know what they're talking about. I argue, and I agree, I think everybody agrees with me as well. You can't amend your agreement to capture bonuses either. So if a homeowner or a builder is offering you X, but they're going to give you $1,000 bonus, you can't go back to your buyer and say, well, they're offering a bonus. I'd like to get it. Let's sign an addendum so I can get it. Catchmark's whole argument is that money belongs to the buyer, because what you should be doing is going to the buyer and saying they're offering $1,000. Let's ask for $1,000 in closing costs. I won't take the bonus, because you can't take the bonus, because you can only get paid what you've agreed to get paid in your commission. And if you think about it on a theoretical sense, why is that incentive being given to you instead of your buyer? Why is anybody, a seller or a listing agent, trying to incentivize you to show a house or to get your client to buy the house? They should be giving the incentive to your buyer to buy the house. You should not be trying to push anybody, advise or direct anybody to buy a particular house. That is not your job. That is not your job to tell somebody what to do. Your job is to simply give them the information and let them make the decision. If you are pushing somebody to buy this house because you get potential bonus or more commission, which is what happened in the old days before Setzer, that is violating your fiduciary duty. No ifs, ands, or buts about it. In fact, one of the key terms that Setzer, Burnett talked about was commission steering consumers to a particular builder or a particular home seller so that you could make more commission. That's a breach of your fiduciary duty. There's no ifs, ands, or buts about it. This isn't open for debate. This isn't Gary's opinion. This is facts, okay? You can argue all you want to with me, but it's not going to change anything. That is the fact. The only time you can amend your agreement to get paid more is when you're giving more services. I was going to represent you and give you customer service, and now I'm providing you client service. I can change my commission rate. You had hired me originally to show you this one house, this one day. You decide not to buy this house. Now you want to look all over Columbia. I can change my commission rate because all I was going to do is show you the one house. That's what the agreement said. I'm representing you to show you this house in Spring Valley neighborhood. And that was the agreement. Now you want to go out of Spring Valley and go all over Columbia and Lexington. Now I can charge you a more commission. It is providing more services. It is not working harder, working longer, having to do more, showing more houses. It's not, they were going to buy resale. Now they're going to buy new construction. All of that is the same service. It has to be doing additional service. And I'll probably want to have to do a podcast on this because it seems every time I bring this up, we get lots and lots of questions on it. Moving over to paragraph 2B, payment of the transaction costs are as follows. This remains the way it was, but there's a few changes to it. B1 is where the buyer's paying the buyer cost. B2 is where the seller's going to pay some of the buyer's transaction costs. Under buyer paying the buyer transaction costs, we've added a sentence that buyer will provide or pay for all of buyer's transaction costs. And then we put other than any negotiated amount set forth in a broker compensation agreement, and seller will provide or pay for all of seller's transaction costs. So B1 is very clear. I'm paying all my own costs as a buyer. However, if there's some other negotiated term as to broker compensation, then that's not considered my buyer broker cost, transaction costs. For example, if I'm paying my own transaction costs, but you and I signed a Form 120 or other compensation agreement saying you would pay all of my buyer's broker's commission, then I would use this section. I'm paying my own closing costs, and that's other than the negotiated amount of broker compensation that's agreed to in that Form 120. Number 2 is a little bit different. This is where the seller has agreed to pay buyer transaction costs. It says seller will pay buyer transaction costs not to exceed blank. And then in bold letters, one of the best statements ever put in a contract, any amount entered here is in addition to, say that again, any amount entered here is in addition to and does not include any negotiated amount set forth in a broker compensation agreement. And this section is not to be used to simply restate the terms of any compensation agreement. I don't know why I need to break it down, but let's do it anyway. If you put a dollar amount in there, this is going to be this amount plus anything in a comp agreement or a Form 120. It's not the same number. So if I have $1,000 in a Form 120 and I put $1,000 here, it's now $1,000 in comp and $1,000 in buyer transaction costs. That's $2,000. Do not use this to restate it. And that's what people did in the past. They put $1,000 in a Form 120 and then put $1,000 here under buyer transaction costs and then saying, oh, that was just a restatement. It's the same thing. Well, no, it's not. It's two different things. And we would have arguments as to whether it was the same number or a different number. Right here, I wish there was a way we could make this blink at people when they fill the contract out. But this amount is in addition to any seller paid buyer broker comp. Anything that is in a Form 120 or compensation agreement. This is plus, that plus. And do not ever, ever, ever use this section here under any circumstances to restate terms of the compensation agreement. Quit restating things from other documents in the contract. You do not need to do that. All right, the rest of this pretty much stays the same, responsible for transaction costs exceeding so forth. Now, the second paragraph says seller agrees to allow up to blank dollars of the above seller paid buyer transaction costs to go toward buyer's broker compensation, but only to the extent such compensation is not fully covered by a compensation agreement. I don't know why anybody would put anything but the same amount of money. I don't understand why sellers care. Why would you put zero in here? I don't understand why a seller would say, I'm willing to pay $1,000 in closing costs, but none of the money can go to the real estate agent. What does it matter? And the reason it doesn't matter is, number one, a buyer's agent cannot get paid a penny more than's in their buyer representation agreements. Don't have to worry about the buyer's agents just trying to steal extra money. Cannot happen. They can only get what they've agreed to in the buyer compensation agreement. Because everything's based on a net sheet, the net's going to be the same to the seller, and it's going to be the same to the buyer, regardless where they get applied to. They get all applied on one form called the settlement statement. So whether we apply that $1,000 in buyer transaction cost to the buyer's fees, the attorney fees, the lender fees, or buyer's agent fees. It doesn't matter. Seller's going to net the same thing. Buyer's going to have to bring the same thing. Why do you limit what they put it to? It makes absolutely no sense. But we have to include that in here for the settlement. But if you're representing a seller, please have enough control of your seller to say, guys, it doesn't matter. We're going to put whatever numbers in two, we'll put down there in the bottom as well, because quite frankly, we don't care where the money goes to. We're making the same amount regardless. It doesn't make any sense. Let's make it easier for the buyer to get this transaction closed. Lastly, in this section, we have a note. Any concession advertised on MLS cannot be used solely to pay brokerage compensation. Don't know a single MLS in the country where you still can do brokerage compensation. It's kind of irrelevant, but this has to be in the paragraph. That takes care of the compensation section that was changed. Now we're going to scroll down here and look at a couple of other quick provisions, not much to them. By the way, but as I scroll down, paragraph 21 is where you would mark the fact that you do have a compensation agreement. We check the first box that the documents are attached, and all you have to say is see Form 120 attached or see broker compensation agreement attached here too. That's all you need to say. You don't need to write a paragraph. Buyer agent compensation agreement attached or see Form 120. It's that easy. Now, moving down to paragraph 33, we added the sentence about authority to sign. If an individual is signing on behalf of buyer or seller, e.g. power of attorney, corporate authorization, personal representative appointment, the individual warrants that the party is properly identified in the contract. The individual has proper authority to sign, and the appropriate legal documents will be provided to closing attorney upon request. It's very simple. If you're representing a party who's signing a contract, you have a duty as a real estate agent to make sure that party has the authority to sign. The Real Estate Commission has talked about two things. And as you probably have seen, there's been some memorandums gone out, particularly to brokers, saying that your firm could be audited. We are really starting the inspection process very strongly now, just randomly selecting. In fact, my brokerage got audited. I don't even do transactions. I have the brokerages just to house my license so that I can teach these classes. Nevertheless, in that audit, they said they're looking for two things from your file. If your file gets pulled in the audit, they're looking to see if you have evidence of earnest money. That's one thing y'all need to be very careful about is I know you're not holding earnest money many times anymore, but if somebody's holding that earnest money, you better have a copy or some statement in your file from that closing attorney saying they are in receipt of that earnest money. That's one thing they are told to check for is was there earnest money in the contract and is there evidence that earnest money was paid? This is the second thing. If your client is not an individual, somebody signing as a power of attorney or company or whatnot, they have to have something in the file. You have to have something in the file that says they have the authority to sign. If you're working with a power of attorney, you need to have a copy of the power of attorney in the file. If it's a military power of attorney, it doesn't have to be recorded. If it's not a military power of attorney, it has to be a South Carolina power of attorney, and it has to be recorded in South Carolina to be valid. Send it to your closing attorney, i.e. Blair Cato, and we'll be happy to look at it and tell you if it's a valid power of attorney for the closing. Any type of company or corporate entity, whether it's an LLC, a corporation, a nonprofit, anything of that nature, you need to have some type of written authorization authorizing the person to sign on behalf of the company. Oftentimes, you'll see that single companies do not have that authorization. You might find a client that has opened up his own LLC, maybe to do yard work or whatever, and he's the only member. He probably doesn't have that written document. You'll need to get with your closing attorney at some point to make sure that you get that in the file. When we do the closings, we will draft that for the client. We'll give them a copy, and we can give you a copy to put in your file to prove the authority to sign. Churches. If it's a church, just call an attorney. They're so all over the place, whether they're corporations, nonprofits, 503CBs. There's all kind of different organizational setups for churches you need to get with somebody. Personal representative, if they're going to be representing an estate, they have to have a certificate of appointment by the court. Probably do a podcast on that at some point in the future, but you need to make sure that you're getting the authority to sign. The only other thing I believe we need to go over is mediation. One of the things that you'll notice that is now missing from the contract is a mediation provision. The state association took out the mediation provision in their contract, and the CCRA board asked to do the same thing, and we've done so. The idea behind that is those who want to mediate will mediate anyway. Those who don't want to mediate just ignored the provision. And in South Carolina, we do have alternative dispute resolution anyway. If I wanted to file a lawsuit involving a real estate transaction, when that lawsuit is filed in the county is going to make the plaintiff and the defendant go through mandatory mediation or arbitration before that case can ever be heard. That's part of what's called ADR, it's alternative dispute resolution. Every county now has it. I've been practicing law for 30 years, and we've had it ever since I practiced law. There's no reason to require parties to do mediation, then to file a lawsuit and have to do mediation again. They can just do it through the lawsuit. That doesn't mean that they can't do it now. It doesn't mean that you shouldn't take advantage of mediation. If you have a dispute with your client, or you have a dispute with a fellow realtor, then by all means, let's go to mediation. Let's try to figure this out and resolve it so everybody can go home happy. So once again, I do want to thank the contract committees of CCRA for working very hard to make the changes to this contract, and Taylor and Kim and the entire board for continuing to look out for you guys and to try to get the best contract in place for you. Whether you're a member of CCRA or not, this is a contract everybody should be looking at. If you would like to see more information about this, this is also on YouTube. I know a lot of you all listen to this as a podcast. I've been doing these on YouTube as well. On the YouTube version of this podcast, the contract is on the screen and you can follow along there as well. So it might be something that you want to go over to YouTube and watch for a second time. All right, that's all the time we have for our show today. I hope you'll like us, subscribe to us, and share us. Please let all the other real estate agents know about this. We've got thousands of members of CCRA. We had a webinar this week, and we only had about 250 agents come to that webinar. That tells me there's thousands of CCRA agents that did not see the webinar. It would be a good idea for you to push this out to as many agents as you can, because you will be dealing with those agents who don't know the changes to the contract. And that is very frustrating for you as an agent. Let's get the word out to as many agents as we can about this podcast, about this YouTube video, so they can go through and look at the changes in the contract, which again, I think were outstanding changes. Y'all have a wonderful weekend, and we'll see you again next week for another episode of Dish and Dirt. Y'all take care.